Hi everyone, welcome back to Loyaltiness channel. This is a channel where we learn about the basic laws of Ghana. We break it down. We break it down in simple form so that everybody understands. So we are talking about something very special. When you buy a land from someone, or it's a lease mostly, 99-year lease or something, you get the land from the landowner and you see the indenture or the land document that is given to you, there are some conditions that are written in them. Usually, there are some conditions that says that maybe Loyatina went to buy the land. So Loyatina should develop the land in 3 years. If not, the landowner can come for the land back. It's usually written that, the person is supposed to develop the land within a 3-year period, failure for which the landowner has the right to re-enter, right? Is it possible for a landowner to actually come back for the land that you have actually bought because you failed to develop it in 3 years? Or maybe you refuse to use it for commercial purposes and there's a clause attached to it that if you don't, he can come for it. Can he come for it? If he can come for it, what are the procedure that he has to go through before he can come for it? And then if you are the person who bought the land, I'm using bought in quotes because I know it's a lease, but you are the one who bought the land, what can you do? Does it have to be in court? Does it have to go to court by all means, or the person can come and take the land by force? Whilst you are somewhere, you can just come and take the land. That is what we are going to learn about today. I'm talking about land that's in bare land today. Land. I'm not talking about renting. We'll talk about renting at a later date, but I'm talking about a land that has been leased to you for maybe 99 years. How many years? I don't know. But then if there's a forfeiture clause or a clause that says that the landlord can re-enter at a point, if you don't do something or you don't do that thing, what is the procedure? If you are interested, let's just get straight to the point. So the law says that, some people want to read, so please check the Land Act. There's a new Land Act which was enacted in 2020, Act 1036. And then if you read section 57 and 58 of the Land Act, you see the forfeiture clauses there. Now, the law says that if you have a condition in the lease that says that, if you fail to develop the land in 3 years, the landlord or the landowner can come back for the land. Yes, you can use that. But before you do that as a landlord, this and this are what you're supposed to do before you can actually go for your land. Number one, it says that you have to send a notice to the person who came to lease the land from you. You have to send a notice indicating that, hey, you have breached the condition to build within 3 years, if that is the condition we are talking about. And I'm expecting you to remedy what you have breached. So maybe remedy as in compensation. So come and pay compensation, maybe 10,000 cedis to me for failing to build within 3 years as stipulated in the condition. Or if it is not anything that the person has to do, but it is payment of rent. You say that, you're supposed to pay a ground rent or a rent to me for maybe every 2 years. You have not paid. I'm asking you to come and pay the rent and pay interest on it at the prevailing bank rates. The law says that send the notice by postal mail. Usually when you're buying the land, you're supposed to give your post office number or post office box number to the person. Or the email if you guys have been communicating through email. And in addition, you also have to paste the notice on the land itself. Even if there are trees on the land, paste them at noticeable places on the land so that whoever is passing there can even notify the owner that, hey, your landlord has pasted this on your land. So please take note of that. After you have done this and nothing is done, the person does not come to correct the mistake or the condition he's failing to meet, or the person does not come to pay the rent and pay the additional interest on it, then you can exercise your right to re-enter. The law says that whilst doing this, you can go peacefully and take your land. That is if it's going to be peaceful. Don't use bodyguards, don't use land guards, go peacefully to take the land. Or the person can bring it to you and say, you know what, you come for your land, I don't want it again. Peacefully, there's an agreement. But if there is no peace, then you have to go to court. You, the landlord, has to go to court, or the landowner. You, the landowner, has to go to court and tell the court that, you know what, we had an agreement. We had a lease agreement. Our indenture showed that within 3 years, this person was supposed to build, this person was supposed to do this. He didn't do it. So, hey, help me get the land back. Then the court can help you. Now, the courts, when they are doing this, can do a number of things. The court can say that, you know what, it is just his failure to build within 3 years. Now, let's give him one more time. We are giving you 1 month. Please build it. Maybe the person was supposed to um, use the premise or use the place for commercial purposes only, and now he's using it for residential. The court can give him an opportunity to stop using the place for commercial purposes. The court can make several orders concerning this. And so it's not like immediately you go to court because you've gone to court that you want the land back, immediately the court gives the land back to you. No. The court consider all the situation at hand and decide that, okay, and in this particular case, listening to this person and that person, we believe that this should be done. Maybe the land should be given to the landowner, or the person who came to lease the land should still have it, but you're giving him one last time, one last injunction to do the right thing. If not, we'll know what to do. After the court listens to all the parties, the court can make decision and say, okay, pay this compensation, but go back and do what you had to do. There are occasions where maybe the landowner grants a lease to someone, and that other person also grants another lease to another party. Now, the first person who went to the landowner to get the land may not be doing what is right, and the landowner may bring an action against the person that he had the contract with the first time. The other party who came to also lease from the second person also can also come to court or go to court and say, you know what, my landlord B, got the land from landlord A, and now the landlord A wants to come back for the land because of this and that and that. I am also interested in this case, so please, judges, help me. If they come to take the land, I'll lose my investment and all of that. You can say all of that to the court, and the court can assist you. Now, even if the landlord is able to come to take the land peacefully, any of the parties, whether it is landlord B or landlord A, which in law may be the sub lessee, can go to court and say, this is not good, this is not helping me. Based on this and that reason, please help so that the landowner will not take the land back. So that's something that can be done. Take note that this particular section 57 and 58 of the Land Act is so important that the law says that you cannot go against the procedure in the law. You cannot even put in an agreement that as for us, you are not going to follow the agreement that is in section. You are not going to follow the law which is in section 57 and 58 of the Land Act. So by all means, if you want to re-enter the land and take the land back from the person you lease the land to, then you have to follow the procedure that has been stated in section 57 and 58 of the Land Act. I know there are questions. Let me know what your questions are. I'll attend to them in the comment section, or send me a WhatsApp on my WhatsApp number. I'll leave it in the description box. Until we meet again, have a very, very good time. Thank you and take care. Bye.